Good afternoon. Welcome to Domestic Asset Protection Has Its Time Finally Come. You'll be receiving MCLE certificate materials and a copy of the program in approximately a week. After the program, please take a moment to complete the survey. The survey link's going to pop up right after we finish. I would appreciate if you'd take a few minutes to fill it out. I'd like to thank our sponsors. The tax section and all of its webinars are sponsored by the firm of Hochman, Salkin, Tosher, Perez, PC, specialized in tax planning, tax litigation, civil and criminal. The family law section and all of its programs are sponsored by SoberLink, the White Zuckerman, Warshawski, Luna Hunt firm, and our family wizard. We have flexible membership categories now. There we go. The bar is reorganizing. We're going to have 3 different levels of membership, and the basic level is available to law students and young lawyers for the first 3 years. I'd like to take a second and introduce our speakers. Myself, followed by Bruce Givner, a genius level tax attorney with the firm of KFB Rice. He did his law school at Columbia and advanced tax work at NYU, where he has his LLM. And he'll be followed by Bill Norman of Norman and Zach. Bill's a tax attorney extraordinaire, graduate of Bolt Hall, and also has an LLM from NYU. Asset protection in the modern era typically centers around 3 concepts: contract provisions, limitations on liability, for example, the use of entities, typically trusts or foundations, corporations as well. Trusts are mostly in common law jurisdictions like the United States. Originally, when I first got involved in asset protection, you were using only offshore jurisdictions that would have 2 characteristics. One, they would not enforce foreign judgments, meaning non-local judgments. And second, these jurisdictions all required that both the trustee and the beneficiary the courts have jurisdiction over them. And since rarely were beneficiaries ever in these foreign jurisdictions, the courts would not have jurisdiction and would not enter judgments. Starting in 1984 offshore, we had the International Trust Act and the Cooks, and that started the concept of designer legislation, where countries and then later states would start adopting very specific rules, creating asset protection trusts. Our topic is the use of domestic asset protection trusts. Back in '97, in April, Alaska enacted the first statute, followed by Delaware in '97, and today there's over 17 states that have domestic asset protection trusts. So when you read some of these cases and they talk about public policy, you got to be careful because public policy is clearly shifting. And some states like Nevada, for example, they created their asset protection trust legislation in response to physicians who couldn't get malpractice insurance and were leaving the state in droves. So they had a very simple scenario initially. You'd set up a trust, make it irrevocable. 2 years later, your assets were protected. And so you have strong public policy in some of these states for allowing these kind of trusts. Notwithstanding the fact that we're approaching 30 years of domestic asset protection trust, we have really very few cases that are helpful. And the ones that are unhelpful tend to be outcome driven, as Bruce will talk about later. They're bankruptcy, a lot of them. Also offshore, civil law foundations have become a great tool for asset protection. Most recently, Wyoming has enacted a Statutory Foundation Act last year. And so you might start to look at those. The third prong of good asset protection is the inability of creditors to collect as we're going to see in several of the cases we're going to talk about today, doesn't matter who won the case, the creditor is not going to be able to collect. And so that makes the big difference. Turning to the first case, which is on our first slide, is the Bosarge case out of Texas. Where else but good old Texas. And it's a really fun case in terms of facts. Ed was in his 80s, was married 30-odd years. When he and his wife were married, they had almost no assets. As often happens later in life with billionaires, Ed took up with a 20-something and shortly thereafter divorces his wife. The wife comes and says, no problem. We were worth nothing when we started, and now we're worth about $2 billion. So just write a check for 1.5 and I'm out of here. And the husband says, wait a minute. We only have a couple of $1 million in assets. We have no assets. Everything is held in trusts. Some 30-odd trusts. Originally, they were set up offshore. Then he got a little nervous and he brought the assets, the trust back, and he's claiming he doesn't have any assets. His assets include things like a 37,000-foot house. I have a nice house. My lot is only 7,000 feet. He has a $45 million flat in London. He has a 70-acre Bahamian island. They have a $5 million mummy, a collection of yachts, one of which is 180 feet long. And the wife's jewelry, including a $2 million diamond necklace, are all owned by the trusts. Ed and his wife have very little. And so far, the wife has spent near $2 million in legal fees. She may end up with very little by the time the dust settles. In the end, Ed moved most of his assets to a series of South Dakota trusts. There are estimates that between $250 billion and $900 billion in assets are now stashed away in Dakota trusts. So it's becoming a great place to be. The wife, Maria, went to South Dakota, went to court there, tried to force the trust to disclose information about their assets. And the courts there said, nope, you're not entitled to discovery. So now in Texas, Maria is going to have one heck of a time trying to prove that the assets in these trusts are community property trusts. Originally, Ed started toying with trust back in 1983, after the Attorney General got an injunction against him for securities manipulation. His first trust was actually established by his then sister-in-law, who was a citizen of Namibia. And the beneficiaries were the kids from his first marriage. So all along, Ed has taken the position that none of the trusts and the progenitors of the original trust were set up by him, and that he had little control over them, although obviously they've made great use of the trust assets. So he started getting nervous around 2012 with the IRS starting to go after offshore trusts for failure to report, the FBARs, and all the other problems and suspicions that are cast on offshore trusts. So he decided he's going to move them all to South Dakota, which he did. And he took liberal use of decanting statutes to move the assets around. The case was set for trial in April. It's now been postponed. I think there's a November date. Not sure it's going to go forward in November. But it's a case to keep your eye on. And if anything, the rule that's likely to emerge from this is, if the courts don't have jurisdiction over the trust assets, it may be very difficult to enforce an ultimate judgment. My fellow speakers, anytime you want, just chime on in.
Well, this case, Howard, obviously springs intellectually from In re Cleopatra Cameron Gift Trust,
which we'll get to.
Which you're going to talk to. And so what makes this case so interesting is presumably Marie in trying to seek enforcement in South Dakota will continue to lose in South Dakota all the way up to the Supreme Court of South Dakota. The issue is, number one, what will happen in Texas? And number two, will someone, whether it's in the Cleopatra Cameron case or in the Bosarge case, try to get this somehow to the U.S. Supreme Court to determine whether the South Dakota Supreme Court's decision on full faith and credit, Article 4, Section 1 of the U.S. Constitution, was properly applied by the Supreme Court of South Dakota in the In re Cleopatra Cameron Gift Trust case. That's really what's interesting about Bosarge and the Cameron case. So that's what we're looking for.
Let's go to the next slide.
Would be if it's community property, and I can't remember whoever the wife's name is. She was presumably executed any conveyances into the trust, so half of it's not even in the trust. You can't, and this depends on the community property law, but the husband wouldn't necessarily be able to move his wife's community property into any trust, so it's not even in the trust under some theory.
But she's going to have to prove what the problem is. She's going to have to prove what the assets are, and obviously the things that she deals with and sees, she knows, but the business interest, the cash, the investments, she doesn't probably have much of an idea. Let's go to the next slide. This Cry case. Cry is a bankruptcy case. One of the rules that Bruce and I have, stay out of bankruptcy. Like Bosarge, the trust was set up by somebody other than Mr. Cry himself. It was set up by his parents originally, but with a nominal sum, and it was an irrevocable it's an irrevocable trust with a spendthrift provision. Over the years, Dr. Cry and his wife transferred assets and business opportunities to the trust, and they always contended that it's not a self-settled trust, meaning they didn't set it up. It was set up by his dad. Texas would not treat the trust as a sham under state law, so the bankruptcy court had to take a look at each asset and make a decision with regard to each asset. In 2005, bankruptcy laws were changed, and we have the Bankruptcy Abuse Prevention and Consumer Protection Act, which brought a number of anti-asset protection features into the bankruptcy law. One of them is if you move to another state and try and claim the benefits of homestead for the new state, you have to have been there for 1,215 days. Nice, easy number to remember, makes sense. And they also said that if you set up an asset protection trust, they have a long statute of limitations to unwind it in bankruptcy, and it's 10 years if it's a self-settled trust. But they also use the phrase, or other similar devices. Cry is a case about what other similar devices really means. And the court went and said, we think that this is effectively an asset protection trust under another name, and it's one of these, quotes, other devices. The court also said, erroneously in my view, that public policy does not constitute devices where one frees his own property from liability of his debts. It's universally recognized that one cannot settle upon himself a spendthrift or protective trust. And that's clearly not the law in the United States anymore. You have 17 states, as I said earlier, where you can self-settle a trust. So, this is more of what I call outcome-driven. This is a matter of a court trying to do what the court wants to do and to come out with a decision that they favor, as opposed to laying down, articulated rules. The court did not, unfortunately, talk about or set standards for what similar devices are or how you would analyze them. They just sort of came to that conclusion.
I mean,
have comments, boys?
Yeah, my comment would be it's a self-settled trust. Now, you take it even more extreme. If the parents put $1 in and then all the other assets came from, our debtors, I think it's a self-settled trust. I think this is look at the substance of it. It's certainly the tax rule. You can't have you can have multiple settlors, but each one who put assets in as a settlor. I think the same rule should apply here. Or to take the other challenge, I think this is obviously I don't have all the facts here, but it appears to be a device to hinder creditors. So either way, there's debtor should lose, in my view.
Okay. The next case, next slide, is the one Bruce was talking about earlier, which is the In re Cleopatra Cameron Gift Trust. Again, these have wonderful facts in these cases. This was about a full faith and credit to enforce a California child support judgment. The Cleopatra is a California resident. Her father actually set up the trust. He established there was a revocable living trust for himself and a gift trust. And when Dad died in 2001, the trusts were funded and became irrevocable. Cleo, a few years later, marries Christopher, and they live in Santa Barbara, had a couple of kids. They were getting about $40,000 a month from the trust, and Chris divorces Cleo. Now, why do we have a case like this? Guess how much Chris was earning. Apparently, he never earned much of a living. The court said he had, quotes, a relative modest income from part-time employment. So first rule, like I said, I look at asset protection holistically. I like to start with contract provisions, which could limit liability. In this case, a prenuptial agreement would have ended the case and would have solved the problem. We wouldn't be here talking about it. As the divorce was kind of chucking along, Cleo moved the trust from California to South Dakota. The trust was eventually joined in the divorce action, and the court issued a child support order. Originally, we had Wells Fargo as the trustee, and we had a series of institutional trustees. It went from Wells to Mellon to Citicorp, and then finally to Trident, which is a local trust company in South Dakota. Trident made a few child support payments and then stopped making payments. When the court went to look at this, they said real simply, providing full faith and credit does not mean that a state must adopt the practices of other states regarding time, manner, and mechanism of enforcing judgments. Enforcement measures do not travel with sister state judgments as preclusive effect. And that's the real key here. We have in California provisions which are unique. We'll talk about one in a few minutes about spendthrift trust, where creditors can still get access to part of the corpus of the spendthrift trust, but that's a California statute. South Dakota doesn't have a rule like that. California has rules which allow corporations and LLCs to be pierced and creditors to get at the membership interests. We didn't have those. That's a procedural rule, not necessarily a substantive rule. And this case stands for the proposition that you don't have to give full faith and credit. The California case I was talking about is Feely versus Reynolds. Bill or Bruce, you want to talk about that for a second?
Feely versus, this is the Carmack decision decided 2 years ago by the Supreme Court that dealt with the conflict we've been living with for decades about Probate Code Section 15306.5 versus 15307, where it wasn't clear whether the 25% limit applied to both sections. This was an appeal to the California Supreme Court from a Ninth Circuit BAP decision because they said, as we've been saying for decades, which is we don't know how do you reconcile the two code sections. And the Ninth Circuit BAP said, we don't know how you reconcile them either. And only the Supreme Court of the state of California said, yep, the 25% limit applies. And basically what you know is that, you know, California has actually a pretty good law when it comes to setting up an irrevocable trust for the benefit of someone else. if the trustee has complete discretion, then the judge cannot order the trustee to make a distribution to the beneficiary's creditor. All the judge can say is, if you, the trustee, decide to make a distribution to the beneficiary, I can order you to distribute up to, not to exceed, 25% to that guy over there, the creditor of the beneficiary. So it's a very, pro-beneficiary decision, which resolved something we haven't known for 30, 40 years.
The next case is Ransom.
One comment. I think maybe when Cleo moved the trust, which must be some power she had, I don't know whether it was to protect her or what, but I think that could be avoidable transaction in itself. It's an exercise of a power, which is equivalent to a transfer, I think, or at least you can find that to be the case. In which case you'd have a California avoidable transfer before it even starts. I think that occurred, I don't know how many years you've got in here, but you've got a question of the statute of limitations possibly running on a California avoidable transfer. And then the situation would be, how is it enforced? It's usually against the transferee. But if that's a remedy, then South Dakota law applies. If the conflicts rule in California's avoidable transfer rule applies, then it's a California determination that the trustee doesn't have, the new trustee or the multiple trustees in South Dakota never got the property, or at least it's recoverable.
You have the same problem though, Bill. The South Dakota Supreme Court decision was two decisions. Number one, we give full faith and credit to the California family law decision. You're right. The trust is liable for the South Dakota trust is liable for the California family court order. However,
what's happening, Jeff?
When it comes to enforcement, we will not give full faith and credit to the California family court decision.
So, by what the avoidable transfer means, if it never became the South Dakota trustee's property, then it's not a question of going into the trust.
It wasn't the decision of the California court, Bill. It was strictly a support order.
To take an extreme, if you steal money and put it in the South Dakota trust, it's not protected. Let's put it that way.
Well, not for luck enforcing against the
assets that are not validly in the hands of the South Dakota trust, then the South Dakota rules don't really apply.
Well, you still have to enforce it if the trustee in South Dakota has the assets. And the trustee is a formidable trustee. It's not a local trustee, Howard. Trident is in 25 jurisdictions around the world. It's a sizable trust company.
The Cleo case involved the Spendthrift Trust. There was a third-party trustee, so that's a question that it's not exactly the same as avoidable transfer. So it may or may not apply. Depends on what they do with it.
Well, you can be confident that if Nevada, South Dakota, Delaware, Wyoming got a trust involving a domestic asset protection trust, they're going to rule the same way, which is
funded by avoidable transfer. I don't think so.
Well, again, if the assets are in the hand of the trustee, they're in South Dakota, Delaware, Wyoming, Nevada are going to say, lots of luck. Try and enforce it. You can't here in South Dakota, Delaware, Wyoming, Nevada.
Because they're going to treat it as a remedy, not a substantive right. Anyways, let me move on.
Yeah, let's
move on. Case.
We'll disagree on that anyway.
Is a gentleman who years before he had a problem set up a trust in the Cook Islands with $9 million, which he got from the sale of a business. He then went on to form a new business, never bothered to deliver products that he was advertising, and the FTC ended up with a judgment against him. They went to collect. He goes and files bankruptcy. Again, big mistake. And in the midst of all this, he moves the trucks from the Cooks to the Belize, thinking that he'd be in a little better shape. The bankruptcy court, again, said public policy, blah, blah, blah. We're not going to honor the trust. However, one of the things the trust did is they went and bought annuities. And there's a statute in Florida which says you cannot shield your assets from liability by converting them on the eve of a finalization event, like a judgment. However, the court here said he didn't convert it. The trustee converted it. So the annuities are protected. They're protected under local law. And as a result, good luck. You're never going to be able to collect on this. To make matters even more enjoyable, the trustee of the Belize Trust went to the Belize Supreme Court and got an order from the Supreme Court there that said the U.S. decision relating to this is unenforceable against the trustee and the trust. So this is a case where bankruptcy won, but they ended up losing. Campbell,
Howard, you're saying if I take I'm in Florida, I take assets, I put it in the Florida trust, the Florida trustee, not me, buys the annuity, it's exempt. And there's no conversion of a non-exempt property into exempt property because I put a trustee in between.
that's what this case held. And then there's just the practicality. How are you going to go after a foreign annuity?
But we're talking domestic. If it doesn't get in,
No, right. But if you had a domestic trust and the domestic trustee converts and buys a foreign annuity, how are they ever going to reach the foreign annuity creditor?
if you have a foreign asset, you're right. But we're talking about domestic asset protection. Yes, if you get involved in a foreign annuity, then you've got a different situation.
Campbell's a real interesting case, which is the next one. He set up a Nevis Asset Protection Trust with $5 million at a time when he had a net worth of $25 million. He later invested in some real estate deals, development deals. They used drywall made in China. The houses developed problems, massive liability resulted, and the guy gets wiped out. Okay. He owes the IRS $1.3 million and does an offer in compromise for $12,000. The IRS at one point came back and said they'd accept $1.5 million, basically no offer in compromise. And he challenges them. The IRS figures out about the trust and says, we're going to include the assets in the trust, which are now 19 plus million, in our demand. So this case ends up before the tax court that held that the IRS could not collect from the Nevis Trust because it was established long before the debt arose, long before he became insolvent, and therefore the service should not consider it when considering his offer in compromise. Now, we don't know what ultimately happened with his offer in compromise, but the IRS was not able to show, at least at this trial level, whether he had control of assets, whether he had control of the funds. So they didn't put on the best of case, and they lost.
So if instead of a Nevis Trust, it was any of the 18 or 19 states that have asset protection trust, the results should be the same.
Correct. The result probably would have been the same. Well, not in California.
No, man.
But you need an asset protection jurisdiction, sure, because he did it long enough ago. The statute of limitations had run.
We have to look at each one, but the 18 or whatever jurisdictions or the 4 or 5 that most people use, if you transferred it in before you had a tax liability on these facts, it should be okay. It shouldn't be challengeable.
Whacker is a wacky opinion. There's 2 families that went to war over each other. Series of judgments were entered. As the judgments were trying to be collected on, one of the co-debtors transferred assets to an Alaskan trust and then filed for bankruptcy. As I said earlier, never filed for bankruptcy. The bankruptcy court kind of laughed at all this and simply said that although the Alaskan courts and the Alaskan statute said fraudulent transfer must be decided under Alaskan law, Alaskan courts don't have, or Alaska legislature doesn't have the power to grant exclusive jurisdiction over those decisions and has no control over what other states or federal courts may do. And so they ended up losing. Not a terribly exciting case. So in the end, we don't have any real good authority which helps us one way or another. I could tell you this: stay out of bankruptcy at all costs, because bankruptcy courts are not very friendly to debtors. Bruce, maybe during his section, will talk a little bit about involuntary bankruptcy, where your creditors, you stay out of bankruptcy and your creditors toss you in it.
Better move on, Howard.
Okay, so then I turn this now over to Bruce.
Okay. Terrific, Howard. Thank you. So one of the topics that comes up is moving out of California, South Dakota, because of the Cleopatra Cameron gift trust case and the fabulous decision that came out of that case, which is, yes, we'll give full faith and credit to the court order in California, but no, we will not allow you to enforce it against our trust. I mean, that's a really good decision. The client's coming to us now, where in the past we probably would have set up a trust under Nevada law, because primarily the availability of the least expensive trust company that we've been able to find in any of the asset protection trust states, which charges $2,500 a year. But now with this decision, it's hard not to say go to South Dakota and use Trident. Trident charges $8,000 as an acceptance fee, which the trust company in Nevada does not charge, and $8,000 a year. So it's more than twice as expensive, but it's hard not to say to the client, gee, wouldn't you like to be able, when they come after you, to say, here's a copy of this case. Why don't you read it? What is it you don't understand? As a way of telling the creditor to go take a hike. So there's a lot of reasons to go to South Dakota. I've listed them on this slide here. The lack of a personal income tax is certainly a good one. Alex, if you'll switch to the next slide. And Trident, as I said, is in a whole bunch of jurisdictions. It's a very large trust company. Go to the next one, Alex. So, oh, by the way, not directly on this topic, but if you haven't read the Buskirk case, B-U-S-K-I-R-K, Buskirk versus Buskirk, which just came out in the last, I think, month, which talks about what I call the long-arm jurisdiction of the probate court in California. And that, I think, Bill would like that case, because it does say that there's very little you have to do to get jurisdiction in the California courts, which certainly we saw in the Dalrymple case, which Bill could talk about if he wanted to, where Asia City, a big trust company in New Zealand, Cook Islands, and other jurisdictions, was held to have made an appearance for purposes of jurisdiction in California. I don't know the court case that well, but I think it was simply because they were directing their marketing into California. The court held that was enough to make Asia City subject to jurisdiction in California. Well, Buskirk is another example of the court saying we have enough ground to exercise jurisdiction. And you can see courts using that kind of, it's sort of like Mayfair. Not much is needed to bring you into the jurisdiction of the California courts. In any event, so they wanted me to talk a little bit about the poison pill. So when we do family entities, we use family limited partnerships. We do not use family LLCs. Why? Because the language that we used to have under the original California Llc Act was gone when California eliminated that act and adopted the revised Uniform Limited Liability Company Act. Bill and Howard gave a great presentation on that. Was it 4 years ago, Howard? 3 years ago? And so this is this series of slides, which we don't have to pay a whole lot of attention to, is the remaining language that limited partnerships have for the ability of, when I set them up, we have the parents, the living trust typically starts off with 97%. The children's trust starts off with 1% as a limited partner, but the children's trust as a limited partner owns the LLC, which is the 2% general partner. And so the idea of the poison pill is, if there's a charging order against the parent's limited partnership interest, the document provides that the children's trust can buy the parent's limited partnership interest for a 30-year interest-only installment note, Wall Street Journal Prime, discounted by lack of marketability and lack of control. And if you look at the statute here, 15907.03, go forward with the slides, Alex, please, to the next one. And this is just the preliminary stuff. Let's go to the next one, Alex. And this is the key language in C1. It says another partner can buy at any time before foreclosure. The interest charge may be redeemed, C2, with property other than the limited partnership property by one or more of the other partners. Now, if we go forward in the slides, Alex, the next one. So next one after that, and we'll get into the Llc Act. So here's the Llc Act as it's been revised. And this is this introductory language is talking about a charging order. It's just like the limited partnership language. Go ahead to the next one, Alex. And this matches paragraph by paragraph, but here's the difference. One more slide, Alex. No, I guess it's one more. Yeah, it's a D. So go ahead, one more, Alex. Okay, and so this is the difference. So this says, at any time before foreclosure under paragraph 3, one or more members whose transferable interests are not subject to the charging order may pay to the judgment creditor the full amount due under the judgment. Well, that's significantly different than saying a limited partner can buy another limited partner's interest without specifying the amount that has to be paid. So at least when you're in a family limited partnership, it's not quite as strict as it is with a limited liability company. That's why when we're doing family entities, we do a limited partnership. Now, if Howard and I and Bill do a deal, we're going to do an LLC, of course. But when you're doing a family entity, we use limited partnerships, and that's the reason for that. So that's the poison pill. When we're talking about moving, let's go to the next one and see what the topic is, Alex. So before I get to bankruptcy, one of my topics that I was supposed to cover was moving out of California. There's a case that I don't know if Howard had in his materials, but you should definitely read this one. This is brand new. It's called Hines, H-I-N-D-S, and Shankman, S-H-A-N-K-M-A-N. That's a law firm versus Lapidus, L-A-P-I-D-E-S. And that was decided, I think, last year, just 2019. Very interesting case. The law firm sued Mr. Lapidus, for a judgment. And Mr. and Mrs. Lapidus were smart enough to move to Texas, because Texas, as you know, is one of those states, Kansas, Arkansas, Florida, that has an unlimited homestead exemption. And the California court said to the law firm, sorry, Texas has an unlimited homestead exemption. You can't get it. Well, there's no follow-up to that case where, leading into the bankruptcy, where the law firm moved, why didn't they, to push Mr. Lapidus, Mr. and Mrs. Lapidus, into an involuntary bankruptcy. And we'll see, because another slide or two, you'll see that if you have less than 12 creditors, it only takes one person to push you into involuntary bankruptcy. And Howard has already said the rule, which you see here in 522P of the Bankruptcy Code, to get advantage of another state's homestead exemption, you have to live there for 1,215 days. So a lot of the advice I'm giving to people, which they never follow, when they call me and they say, gee, I signed this lease for a restaurant and the restaurant is empty now and I'm going to lose all my assets. I say to them, gee, if I were you, I would sell all of my assets right now and buy a very nice, expensive home in Texas or Florida or Kansas or Arkansas or the District of Columbia, and do it now because you want to be there more than 3.3 years before someone gets a judgment against you to take advantage of that unlimited homestead exemption. So nobody takes my advice, but it's really good advice. I think I got to stop because Bill needs time to do his materials. But in any event, there are very interesting cases out there.
Okay, let's start with yeah, here it is. Okay, go a couple more here. I don't even, okay, one more. Okay, this, I don't have all the colorful facts behind all of these either statutes or cases. We don't really have time to do it. But I picked a few points here to talk about domestic asset protection. The first one is my proposition that the only useful exemption under California Code of Civil Procedure from claims of creditors is the private retirement plan exemption. And it's a little bit of a overstatement, but we're in the presidential campaign, so we're able to do these kinds of things now. And what's a private retirement plan? Well, you go to the statute, which is the slide you're looking at here, basically. The exemptions down in the B part of the statute that's here. But the private retirement plan means private retirement plans. And it's got included but not limited to, and talks about union retirement plans, but it's not limited to those. Leaving aside profit sharing for a moment, because that may or may not be a retirement plan, because it's just a way of putting aside profits in your company. Let's go to the next slide then. And the case law, of which there's I think 19 reported cases. There's more than that, unreported, that kind of get, that are available in various forms. But they essentially define retirement plan as a plan is designed and principally or primarily, the cases use different terminology there, but they almost all use the term designed and used for retirement purposes. And I've got a few cases there, including a recent one, which I won't go through in just the interest of time, but I suggest you take a look at it. Kind of summarizes the law. That's the most recent case. So what are we talking about? We're talking about what's a designed and used for retirement purposes. The case law was not uniform. Does say that the retirement plan should be sponsored by an employer. So you can't just set up like the equivalent of kind of your own unlimited IRA, so to speak. Although that's not clear that that's absolutely required. The second thing is whatever you've, and you should set something aside, whatever you've set aside, it should be not more than what's needed for retirement needs. So there needs to be some kind of financial plan based on age, expected retirement date, and some kind of actuarial term, how long you're going to live, plus some latitude so you don't run out of money at the end of your table life expectancy, so to speak. Then the next issue comes up is contribution. When you put all your assets in on day one, you form the company you work for or your own company. Your own company is preferable because of ERISA, which hopefully we don't really have time to do. Maybe Bruce can talk about later if he wants. But assuming you don't have a ERISA type plan, so you own your own company, you're employed, then how's it funded? Well, like most retirement plans, it's periodically funded, but that's not usually the way you want these things to work from the point of view of the potential debtor, so to speak. So can you have a lump sum? If you have a lump sum, do you still have to make periodic payments? I think it would be a good idea to do so. Then there's a question of control. If you control your own retirement plan, is it really a retirement plan? That's unclear in the cases, but generally you should have a trust arrangement where it's a trustee who's separate and apart, and not the same as the potential retiree, the future retiree. And then what do you do with withdrawals? I mean, what can happen, and happens in these cases, after the retirement plan is set up, then the employee wants some distributions. If you get distributions before your retirement, it's hard to call that a retirement plan or a plan for retirement purposes, unless there's some kind of hardship standard that's fairly strictly adhered to by the trustee or the plan administrator. So there's one case that's not on here, by the way, Henry Stern, which is an older case, 345 Fed 3rd 1036, a Ninth Circuit case in 2003, which was a situation where somebody had non-exempt assets and then converted them into exempt assets, which was a private retirement plan, even though there was a pending lawsuit or maybe a judgment in that case. So that's a very helpful case.
Well, the thing about Stern, Bill, is Stern was an IRA, so you could argue it was a partially exempt asset.
Yes, it was. You're absolutely right. They went from partially exempt to exempt. Well, there was a portion that was not exempt, which is the the excess part of that was not covered by the IRA exemption. So let's go to the next topic here, which next slide. Okay, what's new or interesting in Wyoming? Well, move slide or two here, and I picked out and to talk about in detail something called a Wyoming Statutory Foundation, which Howard's already mentioned came into law in Wyoming last year. Next slide. I just kind of summarized the nature of it. We won't have time to, we won't have time to go through all of the details of it. But one of the pieces of it are the organs. We've got an organizer or a founder, which can be anybody. It could be the lawyer. And you have a registered agent, which is somebody in Wyoming. Then you have a board of directors, which is more properly called a council, if you want to use foundation type language. You can't have executive officers, which I don't mention here. So it's usually made up of whoever's on the board or whoever's a council member. Then you have a protector. A protector is very important. That's really the only person that can really change the basic structure and operation of the foundation. Then I mentioned the documents here. There's articles of formation; those are filed. There's a operating agreement, which in foundation language would really be called regulations. But Wyoming, they kind of got half foundation type language and terminology, and half, kind of the domestic type terminology used for trusts and corporations. Then you have minutes, of course, of the board. And then the tax status, which people get worried about. It should say corporation there, I didn't catch that. It can be a corporation, a partnership, a trust, or a disregarded entity. It's all in how you draft it. So it's a very flexible type entity. It probably defaults to a corporation if you don't do anything to try to make it something else. Typically, we try to make it a trust, but not necessarily. The next few slides here, the kind of odd or unusual part of this, it's a kind of ownerless entity. It's not like a trust. It's not an arrangement. It's an entity. It's distinct from whoever set it up or organized it. It's obviously distinct from its beneficiaries, who can be, I believe, discretionary or in a class, and all other persons. It can be forever, even longer than the normal 1,000 years for a Wyoming trust. The next slide is what are its purposes? Well, it has to confer a benefit on at least one person. It's not clear that it has to be, no regulations on this. It's not clear if it has to identify that person, or I could just say a class of persons, which is at least one, or at least a class that has people in it. And it has to be authorized to hold tangible or intangible property. Not hold it, but it has to have that power. Then moving to the next one. This is the content of articles of organization. It sounds kind of mundane, but you don't have to put anything in here about who the owners are, who the board of directors or the council are, beneficiaries. It's just the name and the street address of the registered agent. That's it. The next one. There needs to be an operating agreement, presumably written, but not necessarily clear in the statute, because the statute is just basically what I have here. So the operating agreement is kind of the governing document, like a bylaws or a trust agreement, depending on which way you're going, or a partnership, or like a partnership agreement. I'm going to skip a few slides here. There's more detail, but I want to get to slide 18. Okay. This is the choice of law provision. It says if the transfer to the foundation is somehow ineffective because of a law of a foreign jurisdiction, which I assume could be another state, doesn't mean it means foreign to Wyoming, then it's not invalid. And if it's somehow the transfer avoids forced heirship or some interest under the law of a foreign jurisdiction, which I think could be some like quasi-community property interest, something like that. Community property interest, I would think, you can't transfer unless legally, under whatever law applies to community property, it can be transferred. So if somebody attempts to transfer California community property, I think it's only their portion of it. There's not a consent by the spouse. Anyway, you can't transfer something that you don't really own or have the power to transfer. Then the last few slides on this piece, 19, talk about the limitation on creditors' claims. The founder has no liability with respect to creditors of the foundation. The heirs of the founder don't step into the founder's share, so they can't end up getting control of the foundation. One of the kind of, if you want to call it a benefit, trust lawyers would, or at least academic trust lawyers wouldn't like this, but you can set this thing up so the beneficiaries generally can't change the trust instrument. They can't, after mom and dad are dead, decide they don't like the way this is set up and then all get together and change it, although we'll come to that in a minute. 21 shows that the directors aren't liable. 22 talks about the beneficiaries. There's no charging order provisions here. If you get the 22 here, two more. There's no charging order provision, so the creditors of the beneficiary are out, at least under the statute. The protector has no liability, except, and that's kind of a strange aspect on slide 24. The protector is a situation where a court could impose liability in any of these situations: fraud, inadequate capitalization, meaning of the foundation, failure to observe formalities, what that should say, or intermingling of assets. And then the statute says, well, no one of these except fraud alone is enough to impose liability on the protector. And it goes on to say that certain governing instruments, governing aspects are not events that could cause liability. 25, which is the next one here. What does it take to terminate this thing? Well, the articles themselves could say it. There could be events in the articles or in the operating agreement, or all of the beneficiaries, the founder alive, presumably, the protector, all have to agree as long as it's not inconsistent with the material purpose of the foundation. So you could draft the foundation so it's possible that it could not be terminated, having a purpose is to have it last forever and be a dynasty type arrangement. So going to 26, there's some other interesting things in Wyoming. They have a traditional qualified spendthrift trust like South Dakota and the other 17 or 18 states. They have a statutory trust, which can essentially be like a family limited partnership, if you will, but it has a lot of creditor protection, no charging orders and that kind of thing. And it ends up where there's no default rules in there. So 2704, like valuation questions, valuation rules don't apply to the statutory trust because there is no default. It's whatever you put in the instrument. We have perpetual purpose trusts, which is another kind of ownerless entity that can do things by itself. It could be a protector, for instance, and have successor trustees and so on. But it is a trust. Then a very interesting mechanism is in Wyoming. They have tenancy by the entirety, as they do in Florida, but not in South Dakota, to my knowledge. And tenancy by the entirety is a kind of joint ownership by a husband and wife, where if there's a creditor of one of the spouses, that spouse can't bring an action to either split the property held by tenancy and by the entirety, or to cause a sale and to have the split off of the debtor spouse assets used to pay a creditor's claim. It's a little awkward if you do it without having a trust. So you can put it in a trust, and the tenancy by the entirety status, it carries on into the trust, just like we do in California, revocable trust, where we transfer in separate property, community property, and the status remains the same. We can do the same thing in Wyoming with respect to tenancy by the entirety. And you don't have to be a Wyoming resident to have this kind of ownership. I mean, you can show up at a bank and set up an account, you and your spouse, by tenancy by the entirety. It's a little hard practically, by the way, as I understand it is in Florida, if you have no connection to Wyoming, to try to set up a tenancy by the entirety account directly. This trust gets rid of that because now the trust has a contact with Wyoming, and the banks then will let you set up an account with this designation. They have unregulated private family trust companies, which means there's no minimum capitalization, unlike South Dakota, which has relatively high capitalization requirements for a family trust company. They have single member
Bill, while you're on that topic, Nevada also has unregulated private family trust companies, and Nevada also has something which I've never seen before, which is for corporations with less than 100 shareholders. They have charging order protection for shareholders of corporations. When Steve Oceans came up with that, I thought it was absolutely brilliant. It just shows that he's constantly thinking of ways to come up with stuff that nobody's ever seen. So I haven't seen it used, but having a shareholder of a corporation having charging order protection, that's really cool.
Well, the single member LLC in Wyoming has charging order protection as well, meaning that the exclusive remedy for a creditor of an owner of a single member LLC in Wyoming is a charging order. You can't go to foreclosure. So you can tie it up, but you can't force a foreclosure, at least under Wyoming law. The question that comes up at this point, is let me skip it. But the point is whether a California person that has either a South Dakota or Wyoming LLC, whether that's subject to a charging order in California, or whether you have to, and then foreclosure, or whether you have to apply Wyoming law. It's really the same kind of question of choice of law. But let me just finish up this last point here in a couple minutes. Slide 27 and 28. This is not new. Well, not real new anyway. The California Avoidable Transfer Act, which is kind of a rewrite, essentially, of the former the Fraudulent Transfer Act. What I want to focus on is slide 31, which is a kind of choice of law provision. You go down to B there, it says a claim arising in this chapter, meaning the Avoidable Transfer Act, is governed by the local law of the jurisdiction in which the debtor is located when the transfer is made or the obligation is incurred. And they have a definition up at the top there on A1. Debtor who's an individual is located at the individual's principal residence. So in my view, and when you have California transferors, if you will, of assets to South Dakota, Wyoming, or any of the other 17 states, that if it's a voidable transfer, California would have their own choice of law. And I'm looking at the question would then be, what does it mean to void the transfer? The statute just says it's void, which means it didn't happen. And we get into the Cleopatra case, which is what we're trying to do when we say when California court says it's voidable. Is that a remedy? In which case, under the South Dakota law, the remedy rules are going to be determined by South Dakota, not California. So I understand the Cleopatra case, but that's a little different because it's a third party sponsor of trust and not involving a voidable transfer. Then on slide 32 are just some cases in which the premarital agreement they're voidable. And we've had the Mejia case, which is a California Supreme Court case. Prior to that, not real recent, but not that long ago. Statute of limitations is kind of an interesting issue. This Potter versus Alliance United, which talks about the Cortez case, which is a 52 Cal App 4917. It's a 1977 case, which basically said the statute in California Avoidable or Fraudulent Transfer Act doesn't begin to run until there's a judgment. So the 7-year limits and 4-year limits and those kind of things don't start until you get a judgment under some kind of a common law rule that they can be put in abeyance pending the judgment. The case itself, this Potter case, is kind of strange. There was a case that arose under the fraudulent transfer case. The judge says, well, it's the same as the avoidable transfer case. Same as the case, since the law is almost the same, I'm going to look at it as if it was an Avoidable Transfer Act case. So he starts talking about that. He doesn't go back to the actual law that applies. So that's a little strange case. And then he says because the Cortez case, which was under the prior case, because nobody's ever challenged it, it's sitting there, I'm going to apply it, and the statute doesn't run until there's a judgment. And we've already mentioned the Homestead case, so let's skip that. The last part here, just real briefly, I'm starting on page 34. I have the California Rule of Professional Conduct, not all of it, one piece of it. And this, I always like this, look at this 1A. The lawyer shall not counsel a client to engage or assist or in conduct the lawyer knows is criminal, fraudulent, or a violation of any law ruling or ruling of a tribunal. And then, of course, it has notwithstanding, you still advise what the rules are, of course, and try to determine what they are. So then after that, which I won't go through, I put in things that Howard used to like to talk about, but is now into the stories in the various cases, which is the penal code that deal with various fraudulent conveyances. Now, they require an intent. So it's a fairly high standard. It's not going to be preponderance, it's going to be, reasonable doubt, right? Beyond reasonable doubt. So 531, which people talk about. Then 37, which is a removal of property out of the state, including South Dakota. That also can be a crime. And then if you have an action pending and you try to conceal or dispose, or that can also be a crime. And then you can aid and abet the commission of a crime, which is on page 39. You can conspire to commit a crime. You can have a federal wire fraud violations because you're doing things out of state if there's an underlying crime, which includes fraud. And then you can even have a RICO criminal violation as well. It's wire fraud is one of the predicate offenses in there. So what does it mean practically? Before I get to the last slide here, I think it means you need to have a reason, a substantial reason, a principal reason of estate planning or business planning when you do work that results in using a domestic asset protection technique, other than just incorporating and simple things like that. But if you're starting to use South Dakota Trust, Wyoming Trust, and foreign trust for sure, you need to have a situation where there's not clearly intent. Obviously, there's no creditor on the horizon. It's easy to establish that. So
you mentioned one of the penal code sections, 18 U.S.C., whatever that was, but everybody should be aware of 18 U.S. Code 371, which is the so-called Klein conspiracy. It's the broadest conspiracy. It's the easiest way to get someone in a felony. It says if two people conspire together and one takes an overt act, both parties go to jail. So you don't want to help someone do asset protection planning if one of their goals is to not pay their federal tax liability. That's called going to jail.
Right. Yeah, taxes for sure. Yeah, the predicate offenses are sometimes they're federal offenses and sometimes they're broader, include state fraud. For wire fraud, it doesn't have to be a violation of federal law. It's just a violation of law. And then once you get a wire fraud, then you can bring in RICO, and not that the Attorney General or the U.S. attorneys are that interested in these kinds of cases, but in a business situation, it can be there. So I come to the last point here over time, which is the answer to the question, which is the title of the webinar, is has the time finally come, meaning for asset protection? So I have 5 choices here. Yes, it has, which assumes it was not there before, or it was not as good as it is now, presumably because of Cleopatra, and maybe other legislative developments in various states. No, it's still not good, never was. Or there's limited circumstances where you can do it, or you don't do it until Jay Atkinson retires. And if you don't know Jay Atkinson, you should Google it and read his articles in Forbes, where whenever the debtor wins, it's because the creditor didn't use the right approach, or the creditor wins, they should have won, basically. He has some very creative applications of the Avoidable Transfer Acts to most asset protection planning situations, especially if there's not a long time period between when the transfer takes place and when the claim arises or attempts to be collected.
You want to deal with the Q&A, Bill? There's 5 questions on the Q&A, Bill.
Oh, man, let's get them. What we got here? Oops. Somehow I lost it.
How are the Wyoming trusts taxed by the IRS? Is it like an LLC? I think Bill answered that when he went through his materials, which you could elect.
You mean a Wyoming foundation or a Wyoming trust?
Yeah, I think I would have thought they meant foundations. You're right. I didn't see that. How are Wyoming trusts taxed by the IRS?
Depends on how it's drafted, like a trust. It could be grantor, non-grantor. So there's nothing special about Wyoming. If he meant foundation, it depends on how it was drafted. And you could draft it, as I suggested, as a corporation, partnership, trust, or a disregarded entity.
All right, so the next one is it correct that you can get a Wyoming court judgment that a Wyoming court trust is subject to Wyoming court exclusive jurisdiction if a Wyoming trust manages the trust in Wyoming? I think he means if a Wyoming trustee manages the trust in Wyoming. I think the answer to that is depends on what the assets are.
Yeah,
real estate in Wyoming, you're probably okay.
Yeah, you can probably get that declaration. It has been done, and there are judges that will do it in Teton County, to my understanding. I haven't typically done it, but you can do that. It's to try to preempt the litigation, so to get it in Wyoming where it's going to be favorable. Same thing, if you could do such a thing in South Dakota, it'd be the same kind of thing. You want the litigation to be in South Dakota or Wyoming or wherever your protection vehicle is.
All right, so the next one is, does Kastner provide any guidance beyond its application to the North Carolina and New York parties? I would say there's other states, but it certainly doesn't apply in California to California's ability to tax a non-resident, non-grantor trust. Anybody want to add to that?
Let's see, I'm looking at the chats.
I'm giving you the Q&A. The last Q&A is, may you set up a Wyoming Protection Trust or Nevada that is funded by California real property? The answer is, of course you can set it up. The question is, what is a judge sitting in downtown Los Angeles going to do with that?
It's virtually unenforceable. Years ago, we had a big home on Sunset which had naked statues with parts of the body's autonomy painted in.
That's
And it
been
was owned
great.
by two Netherlands Antilles companies. And the judge in Santa Monica ordered the Antilles companies to show up here with detailed information on the source of funds. And when they failed to show up, the judge said, okay, I'm clearing title to the property.
Exactly. I've always said to people that if the judge can see the property out his front window, he doesn't care what name it's in. You can make it a Nevada trust, a Nevis trust, or a trust on Pluto. The judge in downtown Los Angeles doesn't care.
Well, he has to come up with some theory. You know, he can't just, I think.
As they said in Jurassic Park about all dinosaurs being female, nature will find a way. I say the judge will find a way.
Yeah, well, let's not get into that. So it's a matter of legal philosophy, whether you just look at the outcome and then try to find the reason, or whether you actually try to figure out what the law is.
Okay.
You open the chat because we have a couple bankruptcy questions, Bruce.
I think, tell me what the bank, let's see if I can find.
It's the DAPT specifically under the bankruptcy code.
Yeah, I answered that in the chat.
It is specifically in the bankruptcy code. That is the 10-year rule.
Right. And the language of 548E says self-settled trust or similar devices. So a DAPT is clearly a self-settled spendthrift trust. And I answered that in the chat. Thanks.
Okay.
Any questions to which we have not gotten?
It says there's a good argument that it's irrelevant to California ability to.
That was my answer to the Kastner question.
Okay.
If anybody else has any questions,
Right.
feel free to email Howard or Bill. My email address is bruce@KFB, that's King Francis Bruce Rice, RICE.com. So if you email any one of the three of us, I'm sure we'll be glad to try and give you our best answers. I think we're way past time right now. It's 1:48. So we should say sayonara, right, Howard?
Okay.
Thank you all. Thank all 142 people who are here today for being here. And if we can help you, just send us an email. Thank you very much. Have a lovely rest of your day. Thank you, Alex, for monitoring the program. Pleasure working with you, Bill. Pleasure working with you, Howard.